I see you out there. The coffee is going cold, the highlighter ink is running dry, and you're staring down this massive mountain of contract law cases, just kind of wondering how you're ever going to remember all of it for finals. Look, we've all been there. Contract law can completely feel like a maze of outdated terminology and endless exceptions. But hey, don't worry, because today's explainer is your ultimate streamlined revision guide for one of the absolute most critical landmark judgments you need to know. We're talking about the 1954 Supreme Court case on the Doctrine of Frustration, Satyabrata Ghose versus Mugneeram Bangur Co. So sit back, take a breath, and let us do the heavy lifting for you. We are going to lock this case right into your memory. To really understand the stakes here, I want you to picture a super relatable scenario. Let's say you've saved up for years, right? You finally buy the absolute perfect plot of land to build your dream home. You pay the developer, sign the contract, and you're just sitting there waiting for the keys. But suddenly, before you can even move in, the government swoops in and seizes the land. And the developer? They just throw their hands up and say, sorry, out of my control, the deal is off. Does an unexpected event like that automatically cancel a contract? Does the developer seriously just get to walk away? That right there is exactly the real-world tension at the heart of this case. Okay, let's dive into our exam syllabus for this explainer. First, the background facts. Second, the core legal issue. Third, the test for frustration. Fourth, the final legal ratio. And finally, a quick exam recap. Section 1. The background facts, a post-war contractual nightmare. So here's how this whole dispute unfolded. In Phase 1, Mugneeram Bangur Co., which was a major property developer, launches a new residential township near Kolkata. In Phase 2, our plaintiff, Satyabrata Ghose, steps up, buys a plot, and pays a substantial chunk of the price up front. Everything is going perfectly smoothly. But then, Phase 3 hits. We're in the post-war period, and the government of Bengal steps in and requisitions a part of this township land for military purposes. Now, here's a massive exam tip for you. Seriously, grab your pen. The government requisition was strictly temporary. Write that down, underline it twice. It was temporary. But over in Phase 4, the developer, who was probably just seeing a really convenient exit strategy, immediately contacts the buyers, claims the contract is now impossible to perform, and declares the agreement legally frustrated. Ghose, understandably, refuses to accept this and drags them straight to court. Section 2. The core legal issue. Is temporary delay a legal impossibility? Now, what's really interesting here is how clearly the battle lines are drawn under Section 56 of the Indian Contract Act. On one side, we have the plaintiff, Satyabrata Ghose. His argument is incredibly straightforward. He's basically saying, hey, the military requisition is only temporary. Once the government leaves, you can still develop the land and give me my plot. Mere delay doesn't give you a free pass. On the other side, the defendant developer is arguing the exact opposite. They're saying the government seized the land. We cannot deliver possession within our intended timeline. Performance is literally impossible now, and therefore, under Section 56, the contract is completely frustrated. The tension is palpable, right? You've got the buyer demanding his land and the developer demanding a legal escape route. Section 3. The test for frustration. Justice B.K. Mukherjee's interpretation. Let's see how this builds our understanding of the law. Section 56 of the Indian Contract Act deals with agreements to do an impossible act. But Justice Mukherjee, who delivered the Supreme Court's judgment, did something absolutely vital here. He looked right at the word impossible and essentially said, look, we are not going to interpret this in a purely literal or strictly physical sense. For your exams, you absolutely must understand that the legal definition of impossible in India is way broader than just a physical roadblock. The court determined that impossibility actually applies when an unforeseen event steps in and completely destroys the very foundation or the underlying purpose of the contract. I want you to slow down for a second and really listen to this VIP phrase, radically or fundamentally different. If there is literally only one phrase you remember from this explainer, make it this one. Justice Mukherjee emphasized that for a contract to be frustrated, the intervening event must change the nature of the outstanding obligations so much that asking the parties to perform them would mean asking them to perform a contract radically or fundamentally different from what they originally agreed to. It's just not enough that the contract simply became more difficult to complete. It's not enough that materials became more expensive or that there was some frustrating delay. Hardship is not frustration. The very DNA of the agreement must be destroyed. Section 4. The final legal ratio. The definitive ruling. So, the crucial point is this. The Supreme Court ruled in favor of our buyer, Satyabrata Ghose. And why? Well, because the government's military requisition was merely temporary. It did not permanently block the developer from building the township. Yes, it was a massive inconvenience. Yes, it caused a delay, but it did not destroy the fundamental foundation of the contract. The developer was still legally bound to deliver the land once the military packed up and left. And this exact quote, this is pure gold. This is the highly citable legal ratio you need to memorize and proudly write into your exam booklets. A contract is frustrated only when a supervening event destroys its very foundation or makes performance legally impossible, not merely because it becomes difficult, delayed, or more expensive.
Finally, Section 5, Exam Recap, the 3 core takeaways.
If you're ever given a problem question on the Doctrine of Frustration, just run it through these 3 core takeaways from the 1954 judgment. Number 1, a temporary interruption, like a short-term government requisition, does not equal a permanent block to performance. Number 2, mere commercial hardship, inconvenience, or extra expenses absolutely do not equal legal frustration. You don't get to just abandon a contract because it became a little less profitable. And number 3, the supervening event must alter the obligation so severely that performance becomes radically different from the original intention. Keep in mind, this case isn't just ancient history. Courts literally still use this exact framework today for disputes involving massive natural disasters and government lockdowns. Which brings me to a final thought I want to leave you with just to really test if you've mastered this concept. Think about the modern world. Think about recent years. If a modern global pandemic forces the government to completely halt a massive commercial construction project for 6 months, how do you argue it? Based on Satyabrata Ghose, is that pandemic delay merely a commercial hardship that the developer just has to swallow? Or does a strict lockdown fundamentally destroy the very foundation of the contract? Apply the test we just learned, draft out your arguments for both sides, and honestly, you'll be more than ready to completely crush your contract law exam. Happy studying, and I'll catch you in the next explainer.